Hello and a very warm welcome, viewers. You're watching this special presentation of Sansad TV on Directive Principles of State Policy. These principles aim at ensuring socio-economic justice to the people and establishing India as a welfare state. In this edition, we will understand the meaning and nature of Directive Principles of State Policy and analyze the role of government in implementing these principles. So come along. Part 4 of the Constitution of India contains the Directive Principles of State Policy. The founding fathers of Indian Constitution were aware of the fact that an independent India was going to face many challenges. After colonial rule for almost 200 years, the country was left with widespread poverty, hunger, and deep-rooted socio-economic inequalities. The framers of the Constitution felt that certain policy directions, guidelines, or instructions for the governance of the country were required to handle these problems. Legislatures and executive of independent India were expected to exercise their powers in accordance with the direction and guidelines given in this part of the Constitution. Hence, directive principles are certain ideals, particularly aiming at socio-economic justice, which, according to the framers of Constitution, Indian state should strive for. Dr. B.R. Ambedkar, the chief architect of our Constitution, described directive principles as a novel feature of the Constitution. They are in the nature of general directions, instructions, or guidelines to the state. Directive principles embody the aspirations of people, objectives, and ideals which union and the state governments must bear in mind while making laws and formulating policies. The directive principles are the life-giving provisions of the Constitution. They represent the philosophy of social justice incorporated in Constitution of India. Although directive principles are not legally binding by any court, but they are fundamental in the governance of the country. They lay down a code of conduct for the legislatures, executives, and administrators of India to discharge their responsibilities in tune with these ideals. Directive principles in the Indian Constitution are taken from the Constitution of Ireland. But the idea and philosophy of these principles can be traced back to French Declaration of Human Rights, American Declaration of Independence, liberal as well as socialist policy of the 19th century, and our own Gandhian concept of Sarvodaya. The directive principles contained in the Indian Constitution are taken from the Irish Constitution. The Irish themselves had, however, taken the ideas from the Constitution of Spain. The idea of such policies can be traced to the Declaration of Rights of Man and the Declarations of Independence by the American colonies. Similar guidelines were provided in the form of instruments of instruction in the Government of India Act of 1935. Directive principles of state policy aim at making India a welfare state. These principles are classified on the basis of their ideological source and objectives. The directives based on socialist principles include Article 38, that says the state shall strive to promote the welfare of the people by securing and protecting a social order, by ensuring social, economic, and political justice, and by minimizing inequalities in income, status, facilities, and opportunities. Article 39 says the state shall in particular direct its policies towards securing right to an adequate means of livelihood to all citizens. The ownership and control of material resources shall be organized in a manner to serve the common good. The state shall avoid concentration of wealth in few hands, equal pay for equal work for both men and women. The protection of the strength and health of workers, childhood and youth shall not be exploited. Article 41 talks about securing the right to work, to education and to public assistance in case of unemployment old age, sickness, and disability. Article 42 says that the state shall make provisions for securing just and humane conditions of work and for maternity relief. Article 43 says the state shall endeavour to secure to all workers a living wage and a decent standard of life. Article 43A says that the state shall take steps to secure the participation of workers in the management of industries. Article 47 is to raise the level of nutrition and the standard of living of people to improve public health. The directives based on Gandhian principles include Article 40, which says that the state shall take steps to organize village panchayats as units of self-government. Article 43 says that the state shall endeavour to promote cottage industries on an individual or cooperative basis in rural areas. Article 43b focuses on promotion of voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Article 46 says that the state shall promote educational and economic interests of the weaker sections of the people, particularly that of scheduled castes, scheduled tribes, and other weaker sections. Article 47 says the state shall take steps to improve public health and prohibit consumption of intoxicating drinks and drugs that are injurious to health. Meanwhile, Article 48 focuses on prohibition of slaughter of cows, calves, and other milch and draught cattle, and to improve their breeds. The directives based on liberal intellectual principles include Article 44, that says the state shall endeavour to secure for the citizen a uniform civil code throughout the territory of India. Article 45 focuses on providing early childhood care and education for all children until they complete the age of 6 years. Article 48 focuses on organizing agriculture and animal husbandry on modern and scientific lines. Article 48A aims at protecting and improving the environment and to safeguard the forests and wildlife of the country. Article 49 says the state shall protect every monument or place of artistic or historic interest. Article 50 says the state shall take steps to separate judiciary from the executive in the public services of the state. Article 51 declares to establish international peace and security. The state shall endeavour to maintain just and honourable relations with the nations, foster respect for international law and treaty obligations, and encourage settlement of international disputes by arbitration. For amending the directive principles of state policies, the constitutional amendment is required. It has to be passed by the special majority of both houses of parliament. Post-independence, there have been a number of amendments to the constitution, and some of them are pertaining to these directives. The 42nd Constitutional Amendment of 1976 introduced certain changes in the Part 4 of the Constitution by adding new directives. These include Article 39A to provide free legal aid to the poor, Article 43A for participation of workers in management of industries, Article 48A to protect and improve the environment. 44th Constitutional Amendment of 1978 inserted Section 2 to Article 38, which declares that state in particular shall strive to minimize economic inequalities in income and eliminate inequalities in status, facilities and opportunities, not amongst individuals but also amongst groups. It also eliminated the right to property from the list of fundamental rights. 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. Both fundamental rights and directive principles are essential features of Indian Constitution. But there has been persistent conflict for a considerable period between the two. So what is the distinction between fundamental rights and directive principles of state policy? Let's find out. Fundamental rights are legally binding, but directive principles of state policy are not. It means that a person can appeal to the court of law if his or her fundamental rights are violated, but people cannot appeal to the court if the government does not implement the directive principles. Fundamental rights are negative or prohibitive in nature because they put limitation on the state. On the contrary, directive principles are affirmative directions. They declare the duty of the state to achieve certain social and economic objectives. Fundamental rights established liberal political democracy in India. However, directive principles make India a welfare state. Fundamental rights protect the interests of the individual, while directive principles of state policy seek to promote socio-economic equality and particularly provide safeguards to weaker and vulnerable sections of the society. In the first 3 decades of working of the Constitution, there has been a long-drawn debate that in case of conflict between the fundamental rights and directive principles, which of the 2 classes of the constitutional provisions should be accorded priority. With the help of 4 court verdicts, the relationship between fundamental rights and directive principles of state policy is decoded. Champakam versus the State of Madras in 1951. In this case, the Supreme Court ruled that in case of any conflict between fundamental rights and directive principles, the former would prevail. It declared that the directive principles have to conform to and run as subsidiary to the fundamental rights. It also held that fundamental rights could be amended by Parliament by enacting Constitutional Amendment Acts. Golaknath versus the State of Punjab in 1967. In this case, the Supreme Court declared that fundamental rights could not be amended by Parliament even for implementation of directive principles. Keshwanand Bharti versus the State of Kerala in 1973. In this case, the Supreme Court overruled its Golaknath case of 1967 and declared that Parliament can amend any part of Constitution, but it cannot alter its basic structure. Thus, the right to property was eliminated from the list of fundamental rights. Minerva Mills versus the Union of India in 1980. In this case, the Supreme Court reiterated that Parliament can amend any part of Constitution, but it cannot change the basic structure of Indian Constitution.
It is often a question of debate whether directive principles can be enforced by the courts, whether there is any legal force, whether it's illogically arranged, or whether it's conservative nature or may produce constitutional conflict between the centre and state. Over a period of time, many landmark cases have been decided by the Supreme Court of India. For instance, the Dorai Rajan case, the Golaknath case, where it said that Parliament cannot amend fundamental rights to implement directive principles of state policy. It was in the Keshwananda Bharti case, where it was popularly known for laying down the basic structure doctrine. This judgment has played a vital role in recognizing the importance of directive principles of state policy. Earlier conflict between the fundamental rights and the directive principles and the concept of the supremacy of the fundamental rights qua the directive principles of state policy has been watered down to a great extent in the judgments of almost all the judges, though their views were conflicting insofar as the amending power of the Constitution was concerned. The said judgment recognized that both the fundamental rights and directive principles of state policy are equally important and there is no conflict amongst them. It recognized they are supplementary to each other and they are together the conscience of the Constitution.
Directive principles are sometimes questioned for being non-justiciable, vague and moral precepts, whose execution is totally left to the discretion of the government. But successive governments in India have taken various steps to implement these directive principles. Some of the measures in this effect include Article 39. Various legislations were enacted by the government with the objective to organize the ownership and control of material resources to serve the common good. Some of these are land reforms, where land is the most essential material resource in an agrarian country like India. Through land reforms, the zamindari system was abolished, ceiling on land holdings was imposed and surplus land was distributed among landless labourers. Minimum Wages Act, Income Tax Act and other taxation measures to tax high-income groups and provide exemption and relief to the weaker sections. Meanwhile, through 73rd Constitutional Amendment Act 1992, government fulfilled the constitutional obligation stated in Article 40. Three-tier Panchayati Raj system was introduced at the village, block and district level in almost all the parts of the country. To promote cottage industries, as per Article 43, the government has established several boards such as Village Industries Board, Khadi and Village Industries Commission, All India Handicraft Board, Silk Board, Koi Board, which provide essential help to cottage industries for financing and marketing. Government has implemented the provisions related to free and compulsory education as provided in Article 45. Introduced by the 86th Constitutional Amendment and subsequently passed the Rights to Education Act in 2009, elementary education has been accepted as fundamental right of each child between 6 to 14 years of age. Rural area development programs such as the Community Development Program, Integrated Rural Development Program, and Mahatma Gandhi National Rural Employment Guarantee Act were launched to raise the standard of living, particularly in rural areas, as stated in the central government-sponsored schemes like Pradhan Mantri Gram Swasthya Yojana. National Rural Health Mission is being implemented to fulfill the social sector responsibility of the Indian state. The Wildlife Protection Act, the Forest Conservation Act, the Environment Protection Act have been enacted to safeguard the wildlife and forest respectively. The Water Air Pollution Control Acts have provided for establishment of Central Pollution Control Board. The Ancient and Historical Monument and Archaeological Sites and Remains Act has been enacted to protect the monuments, places and objects of national importance.
The objective of these directive principles is to lay down goals to achieve such social and economic conditions under which citizens can lead a good life. They protect the interests of citizens at a macro level. Directive principles have a moralistic disposition because lack of morality would hinder the development of any community. But these directives have been made non-justiciable because sometimes what would happen, the state might be lacking resources to implement them, or at times there is a possibility that state might be having some better plans. So these principles, they serve to augment the fundamental rights, and together the purpose of fundamental rights and directive principles is to realize the goals of justice, liberty, equality and fraternity that have been enshrined in our preamble. From time to time, state has formulated laws and policies to give effect to these principles, starting from the Minimum Wages Act in 1948. Then we ushered in land reforms, tenancy reforms, we brought in the Panchayati Raj, we enacted laws to stop child labor, bonded laborers. Laws were enacted to protect the interests of scheduled castes and scheduled tribes. We enacted laws to prohibit practices that were derogatory to the dignity of women, such as the sati was prohibited. Then we also enacted the Dowry Prohibition Act. We got Equal Remuneration Act in 1976. In a bid to protect our environment, conserve our forests, we enacted various laws to protect the environment. We enacted the Wildlife Conservation Act. And we also had laws to promote animal husbandry. Then we've also given effect to our international commitments under CEDAW by formulating the Vishakha guidelines, which were later made into the POSH Act in 2013, and also to give effect to DWAR, we enacted the Domestic Violence Act, Protection of Women Against Domestic Violence Act. Then we also enacted the Right to Education Act, and the new education policy has emphasis on early childhood and childhood care and also education.
Regardless of the non-justiciable nature of these directive principles, a citizen should be aware of them. The objective of these directives is to better the social and economic conditions of the society so that people can live a good life. Knowledge of these directive principles helps a citizen to keep a check on the government. A citizen can use directives as a measure of the performance of the government and can identify the scope where it lacks. Moreover, it also constrains the power of the state to make draconian laws. even after being non-justiciable, they hold equal relevance and significance as any other provision of the Constitution. Well, viewers, that's all we have for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye from my side for now. Namaskar.